Welcome back, everyone. It is now my pleasure to introduce our keynote speaker, Caroline Crenshaw. Commissioner Crenshaw was appointed in August 2020. While she's been a commissioner for just a year and a half, she's a veteran of the SEC. She served for many years on the SEC staff, including as counsel to Commissioners Rob Jackson and Kara Stein, and also in the divisions of investment management and examinations. Prior to that, she was in private practice, and furthering her legal chops by being an extra in the Pelican Brief. Yes, the one with Denzel Washington? Yeah. In case all of the challenges of her day job were not enough, Commissioner Crenshaw currently serves as a captain in the U.S. Army Reserve Judge Advocate General Corps. Like many of you, she is dealing with all that comes with working remotely while raising a young child during a pandemic. If you hear Paw Patrol in the background, pay no mind. And remember that no job is too big and no pup is too small, something I take to heart. When she doesn't have to listen to Paw Patrol, Commissioner Crenshaw is also a fan of musicals. She actually auditioned for Cosette in Les Mis on Broadway. While she did not get that part, she is not throwing away her shot. She has already made her mark with strong statements on critical issues such as proxy voting, corporate governance, transparency, climate change, and cybersecurity. From her castle on the cloud, please join me in welcoming Commissioner Caroline Crenshaw.
Thank you so much. It's great to be here today, and that is really well done. I appreciate it, and fortunately, my son is not in the office today, so we shouldn't have any Paw Patrol interruptions.
Let's start out by talking about your transition from being on the SEC staff to commissioner. What has been the thing that surprised you the most about making that transition?
And I'll make this short because I know we want to get on to some other questions as well. But, you know, sitting here today about 18 months into my term, I will say the job remains exceptionally challenging. But I feel like I've been doing it long enough now that I understand what the role requires and where my efforts can have the most significant impact. But as far as transition and surprises, I recently looked over some comments I'd prepared shortly after becoming a commissioner. And I acknowledged then the truism of that it's really drinking from a fire hose. And you know, it really truly is. And the biggest surprise for me was just how much there is to know and how much required my input and decisions every single day. I'd been a counsel to 2 commissioners before I came one, and so I really was confident I knew the job well. As it turns out, there's a big difference between being responsible for one defined area of the agency as counsel and being responsible for everything as a commissioner. So that was one of them. And just at the risk of exceeding the scope of your question a little bit, one thing that really did not surprise me, which has been a constant since I first joined the commission as a member of the exam staff and really through today, is that the SEC has the most remarkable group of professionals in government. To the extent I get things right in this role, it's because I have the privilege as a commissioner to be represented by thousands of dedicated attorneys, accountants, and other professionals, and my team. I have a team of 5, and the extent I get it right, it's all of those folks I just mentioned. And I know I personally will get things very wrong, but not for a lack of trying, and not for a lack of the amazing work that the team does to help me get things right. Oh, and before we move forward, I just say the views I express today are my own and do not necessarily reflect the views of the commission, my fellow commissioners, or the agency.
Well, I'm sure they would join you, however, in thanking your staff. It is a great team, and we really appreciate working together with them. Let's start out with what's on everybody's mind today, and that is cybersecurity. The commission just issued a major rule proposal that covers both policies and procedures and incident reporting. Our members take cybersecurity very seriously. It's very important to them. They already believe that the cybersecurity policies and procedures are required under the compliance program rule. We certainly intend to submit extensive comments on the rule. What could you just share your perspective on what gap the commission was looking to fill here in addition to the compliance program rule?
Sure. The risk of cyber incidents are different, greater, more serious in my view now than they have ever been. Cyber is something that keeps me up at night regularly across the board. I worry really across the industry about implications. So while I know your members feel the same way, I believe it never hurts to revisit the requirements to ensure that they're keeping pace with the risks and the real world. But it also serves as an extremely important reminder about the necessity to prioritize the issue, to make sure you're doing everything that you need to do to protect yourself and to protect your investors. In fact, the White House has put out a fact sheet, several, I believe, from January about the risks, the real and significant risk of cyber attacks. And it's really, truly something we need to be constantly vigilant about. It's never an area where we can let our guard down. So in my view, the proposal is designed to reiterate the importance of the issue, to ensure across the spectrum of the investment company, investment advisor world, that the expectations are clear, to ensure that everyone knows what is expected of them and given the real risks. I also think it's designed to better protect investors by ensuring that customers receive timely and meaningful disclosures about cyber incidents. And I think, cyber incidents, as we've discussed, can have really broad disruptions. We've seen this across the board in Colonial Pipeline and some of the other cyber attacks. So gaining some regulatory insight into what's happening across all of these entities is something that's also contemplated, and I think that's important as well.
And in fact, that goes to one of the questions that I think many of us have. In terms of the incident reports, is there a concern that there will be an overwhelming amount of information coming to the SEC and coming to investors? What do you intend to do with the information, and what kinds of ongoing conversations do you expect to be having with advisors who are reporting?
Sure. I think we have good experience with this in the context of the obligation of publicly traded companies to disclose certain types of cyber events. And so I think the goal here is for customers to have sufficient information to be informed and able to make informed decisions. And I expect we'll receive helpful comments from industry and from the technical experts how best to draw that line. And I think one of the things worth certainly thinking about, as I've said earlier, is what this information is going to provide for us if we're looking at a single incident. It's certainly something we're concerned about, right? If we're looking at multiple incidents across the board, this can have significant market implications. So this is information that we need to know when we're assessing various cyber attacks. And so that's some of it high level that I think I could get into more, but I think some of it really is designed at, again, providing investors that information, but keeping us informed about is this an isolated incident? Is this across the board? How significant is this incident? Is it something that needs to result in updates to policies and procedures? Does it need to result in a systems update? Are investors being impacted? Are they not? Could they be impacted in the future? So these are all things that I think we really are looking for in an ongoing dialogue and as part of the proposal.
I know some folks are concerned about the 48 hours in terms of reporting. They're still, probably getting their arms around the information and the ongoing obligations to keep updated. We will certainly be submitting comments on that. What do you see in terms of the 48 hours and what kinds of information you'll be looking for in a short time?
Yep. So first and foremost, we consider all comments and really appreciate the time and effort that goes into submitting them. So thank you for that. As I said, for the short term, I sort of talked about this a little bit before, but perhaps not surprisingly, if one registrant has a problem, we're concerned about that. We want to deal with that. But if multiple registrants are experiencing something, that really can pose a significant challenge. So I expect the information we receive from 48-hour incident reports would help us monitor risks coordinate with law enforcement and other regulatory partners as necessary, all to protect investors and the markets. And I think it likely will also help staff consider when a public risk alert is appropriate. Do we need to let others know? And we cannot do all the analysis on our own for every incident, and nor do you want us to. So in my view, it's important for the entity to continue to provide updates based on what the internal analysis shows. Again, as I mentioned before, regarding scope, customer impact, and a timetable for full remediation, as well as to the extent the entities working or coordinating with other agencies. So I think this is all critical. I went a little bit beyond the 48 hours there, but I think that's all really sort of what's critical in the early reporting.
Well, you know that the investment advisor community is very broad. There are all kinds of different shapes and sizes of investment advisor firms. And I appreciate that the commission asked a question in the release about different kinds of advisors. How do you see the commission calibrating the rule for the different kinds of firms and the balance between keeping it evergreen and the specificity of the guidance?
Yeah, so I think one of the things we're looking at is a rule that provides some flexibility and can allow folks to adapt over time. And I think, I think that's one of the reasons we do, wow, I'm just blanking on the word. Principles-based. Sorry, just totally had a principles-based rules. I think that's one of the reasons we do principles-based rules, is to allow things to continue to be flexible over time as the risks change, as the requirements change, as the world change. But then we always have to go back and look at it. And so I think that's one of the things we're doing now. We're assessing, what's working, what hasn't in the past. Obviously, aspects of it are still working, but we're looking at where we can update some areas, and we're looking for your impact. So I always, again, really look forward to the comments and your thoughts outlining, what concerns you might have if it doesn't strike the right balance as to the frequency of the updates or the total amount of incidents reports or the amended disclosures, and really any ideas you have for how to make it the most useful for you all and for the public. And that's really what a priority is for me.
Thank you, and we'll be asking all of you in the room too for your feedback on the proposal as we submit comments. I know one of the things that folks, one more cyber question, but I know what some of the folks are concerned that there have been a number of cases, enforcement cases, where the advisor themselves sees themselves as the victim of the hack or intrusion. And how will you strike the right balance between collaborating with the advisor community and not seeming, in an adversarial situation?
Yeah, our goal certainly is not to be adversarial with any registrant, just plain and simple. And I think compliant registrants that follow best practices, provide timely disclosure, cooperate with law enforcement as necessary, these are firms that are unlikely to draw enforcement action merely because they're a victim of a cyber attack. There's certainly a perception challenge because our investigations are by law and by design non-public. So you hear about all the settlements we reach and the litigation we bring when we have that, but you hear effectively nothing about the investigations where we asked questions because we learned of a cyber intrusion, and then we closed the investigation with no further action because we did not identify any violations. And so our goal is not to punish a victim. And registrants can certainly help their cause by taking steps really before a problem happens to minimize the potential harm, to have a plan for how to respond and really make sure that they are abiding by all the regulations. And then, if it happens, we deal with it. But that's setting themselves up, I think, the most they can for success.
Well, we appreciate that. Let's turn now to another recent development, the proposal for private fund advisors. In addition to increased disclosure, the SEC proposed certain to ban certain private fund advisor activities, certain contractual arrangements, certain fees and expenses. To many, this represents a fundamental change from a principles-based regime, a shift in approach, and also a shift in approach from retail to more sophisticated investors. In your statement at the open meeting, you noted behaviors that you considered problematic. We'd be interested in your views of why the SEC needs more tools to address private fund advisors, or put another way, why the current tools are not sufficient in your view.
Sure. I think that any place we're proposing requiring more disclosures or outright prohibiting certain practice, it's only after careful consideration and concluding that this is the most appropriate method of delivering on a fundamental policy goal and obligation of the commission, typically investor protection. And that's what it is in this context. And, I'll say I'm not entirely sure this is such a shift. I know there's lots been written on this and there's different views, but as a Division of Exams alumna, which you mentioned earlier, these are issues I've been working on since arriving at the commission. And I highlighted in that statement several of the Division of Exams risk alerts. And to me, these are issues we've really been looking closely at for 10 years. And unfortunately, too often, in my opinion, we have to impose new requirements or constrictions to control behavior of a small number of actors who really seek an unfair advantage of everyone else by dubious means. And so I think this is something we spent a lot of time looking at. I think we believe it's the right course of action for now. But again, it's a proposal, and we look forward to all the comments I know we're going to get.
Absolutely, including from us.
You look forward to it.
The fiduciary interpretation affirms the principles-based nature of the fiduciary duty. What has led you to banning certain practices outright versus relying on full disclosure and management and mitigation of conflicts?
Yeah, so for example, I expect most private fund advisors would agree it's wrong to charge fees for work they don't do. And that they know they won't do. But apparently not everyone has really gotten that memo. So we propose creating a rule to explicitly bar that practice. Similarly, we propose precluding private fund advisors from seeking reimbursement of expenses not directly tied to the fund being charged. Now, I know the perception of private fund advisors is that the people depending on them are sophisticated players who can protect their own interests. But often there really is a significant imbalance in negotiating power, such that the requiring disclosure of unfair business practices is not enough to deter those practices. So if we encounter an advisor putting their interests ahead of their clients, that's a violation of the securities laws. And so we propose being explicit that certain conduct, even if disclosed, is still a violation of that duty to act in the client's best interest. And I think we're at a place where we feel we need to be explicit. And so again, we look forward to comments, but that's again after sort of 10 years, and look forward to comments. Maybe it is a proposal. Maybe we'll get different evidence that coming in the comment file, but that's where we are right now. That's where I am right now.
And you touched on this a little bit, but in terms of, advisors are fiduciary to all clients, we certainly agree with that. Both retail and institutional, it applies to everybody. Given the Commission's priorities and limited resources, what has led you to focus at this time on institutional versus retail clients?
I think really our mission extends to investors writ large. I devote a significant portion of my week to issues of primary concern to retail investors. But our mission is not limited to protecting retail investors or investors until they have a certain level of sophistication. And these proposals, I think, demonstrate what actually constitutes our whole mission. And also, I think increasingly retail investors are impacted by the conduct of private fund advisors, as pension funds and other retirement vehicles increasingly invest in private funds. And I will just note that the work throughout our agency is designed to protect and balance market interests across the board, not just for retail. So in this context, I think that has been a discussion point. But if you look at the commission as a whole, there are often areas where we write rules that affect a balance of very sophisticated players. And so this is not something that's unusual to the Securities and Exchange Commission, even if folks were thinking at this point it looks unusual in this space, but it's not unusual for the commission.
Well, thank you. We appreciate that, and you'll be hearing from us. Again, I invite everyone in the room to work with us on our comment letter. Moving on to something that is going to happen soon, but not yet. The SEC's agency and other agencies have very heavily focused on climate change and ESG. Many of our members have specific ESG strategies or integrate them into their investment decision-making process. We support consistent, comparable, and reliable disclosures from issuers so that our members can evaluate these factors in making their decisions. It looks like the SEC is taking a multi-pronged approach. They're looking at issuers, asset managers across regulation, examinations, and enforcement. I know you're going to come out with a proposal soon, but what is your view on the overall approach and goals?
So I think you really mentioned the key point, providing consistent, comparable, and reliable disclosures in order to facilitate investor analysis. That's my goal. And you're right. I think it is an overall approach, but the guiding principle is really to facilitate investor analysis, both at the asset manager level, but also for individual investors who are allocating their capital to you all or to choosing to invest in particular industries or individual issuers. And so I think we're really looking at it holistically because it is something that crosses sort of, I think, every division, every entity, every path that we deal with at the SEC.
The balance is going to be very interesting in terms of facilitating sustainable investing versus mandating specific factors. We support the facilitation of sustainable investors. We're concerned about leaving advisors the flexibility to best serve their clients. How do you strike that balance in your view?
Well, I look forward to engagement with all of you on this. And as you noted, comparability is a key factor in making these disclosures useful. So understanding those elements that are needed to ensure an appropriate level of comparability is important. Our current disclosure landscape is essentially voluntary at the moment, and we have a file full of letters in response to our request for information, and from a variety of investors, I might add, noting that the lack of comparability and costs to access reliable data that can be deployed in analysis are simply too high. So we'll be looking at all of those things as we're thinking through the various proposals that are coming forward and trying to strike the right balance. We'll do our best, but we will, again, look forward to comments because it's a really significant and broad, as we've discussed, issue. So really looking forward to getting feedback on that.
We look forward to engaging with you and commenting on it. And I know you can't confirm or deny. We hear it's coming soon. Stay tuned. I won't put you on the spot.
You're right. I can neither confirm nor deny.
We'd appreciate a break in all of these, at least staggering all of the proposals.
I hear you. I have to read them all too. It's quite. My reading list at night is quite extensive.
I believe it. It's a lot. Turning to another topic that could be kind of related, I know all of us here are working toward better diversity and inclusion in our industry. We at the IA have been working on it. We've supported legislation that would assist in better measuring progress. We've supported the NASDAQ rules on board disclosure of their overall diversity. I know the Asset Management Advisory Committee at the SEC issued recommendations, including around increased transparency, facilitating analysis of, facilitating the selection of diverse managers. We expect a human capital rule coming out soon. How can the SEC play a role here, more than just kind of serving as the bully pulpit?
Yeah. So first of all, I completely agree with you that more progress needs to be made with respect to diversity and inclusion in the industry. I know you're all familiar with this, but among other things, I think the AMAC found that roughly 1% of the 70 trillion in global financial assets under management are managed by minority-owned or women-owned funds. The percentage of ownership interest by women and people of color in asset management firms is disproportionately low by any and every objective measure. And so I do think the SEC can take action beyond the bully pulp, and it's vital that we do. As you mentioned, we have a human capital rule on our regulatory agenda, so I hope to see us move forward on that soon. I think we could also consider commission or staff guidance that could discourage discrimination by fiduciaries. I think it's critical that the commission continue to work to identify and dismantle barriers that directly or indirectly result in discrimination. So there's areas that I certainly think we can think about, but look forward to any and all ideas you have. I mean, I think this is an area that not just the SEC and the asset management world is struggling with. I think lots of folks are putting deep and serious thought into these issues, and I hope we can all learn from each other and grow together.
What do you anticipate coming out of the human capital rulemaking, the kinds of elements that you're thinking about?
Yep. So given it's on the agenda, there's a limit to what I can say, but I think the chair has publicly stated that he's asked for the staff to propose recommendations on a variety of disclosures, including recommending mandatory disclosures that could touch on metrics such as turnover, skills and development training, compensation, benefits, workforce demographics, including diversity, and health and safety. And when it comes to human capital, I think the goal should be to come up with a regime that, again, sounds familiar, but yields comparable and consistent disclosures. Investors are repeatedly telling us that they view human capital management as linked to financial performance, and others are saying it's essential to long-term value creation. So again, just facilitating disclosures that ensure consistency and comparability, I think is necessary. And I think this is true for, a lot of ESG issues. What information do investors need to make the decision? So that's what I'm looking for, and I'm hopeful that the rulemaking on the subject will bring clarity to what information needs to be disclosed and how.
Well, we appreciate that, and we look forward to working with you on that rulemaking, again, hopefully spaced out.
Understood.
But we, and I'll put in a plug for longer comment periods.
Yeah, that's an interesting, I don't know if you want my take on that.
I sure do, yes.
One, because, as I mentioned, I get 30-day drafts as well. So that's what I get to review the rules. So I recognize there's long rules. I've read all of them as well. So I know the 30-day time limit can put a burden on everyone. I think it's interesting, as the chair pointed out, the deadline is 30 days from the time the rule appears in the Federal Register. So that typically adds a week or two to the comment window, sometimes more. It seems really varied. Sometimes it's a month, although we've also noticed that at times it's shorter than that.
Right.
So some of our most recent proposals, as you may have noticed, have taken the approach of providing no less than 60 days for comment. So it's 30 days from publication in the Federal Register or 60 days after issuance, whichever is longer. So again, I know these are long rules. I read all of them. And I appreciate your diligence in reviewing them and providing helpful feedback.
Well, thank you. We appreciate that. And we are going to continue to put in our plugs for longer comment periods.
Fair enough.
Why don't we turn to a broader issue and away from the specifics of these rulemakings? What do you see as the top challenges facing investors today?
Yeah. So on a macro level, I think a challenge facing a lot of retail investors specifically is the fact that our society is depending on individuals and advisors to help individuals save for their own retirement, rather than relying on defined pension plans. So we have retail investors contending with volatile markets and newer risky asset classes while trying to manage their retirement savings or their savings for their children's education or their new house or whatever it is that they're trying to save for. Basic food, whatever it is. So I think complex products can pose a real challenge. Leveraged and inverse exchange traded products are one challenge, but any products that don't have an intuitive payoff structure are something that I'm certainly thinking about. I put out a joint statement on that topic with Commissioner Lee last year, and it's something Chair Gensler has spoken about as well. So I'm hopeful we might see some improved investor and market protections there. Another one is the growth of the private markets. Private markets can be lucrative, but when compared with public markets, they're opaque, less liquid, can impose higher transaction costs, and are really more susceptible to valuation errors and prone to fraud. Some studies suggest significantly prone to fraud. So many retail investors may not even know the extent to which they're exposed to the private markets, and they're unlikely to have the ability to obtain adequate information about the businesses and operations of those companies. So that's another area I'm thinking about. And just quickly, I know I'd be remiss if I didn't talk briefly in this question about crypto and its rise as a investment class, which I think is a real challenge for investors. It's entered the mainstream with billboards and Super Bowl ads, but it remains highly speculative and a risky asset class. And investors do not typically get the benefits of compliance and robust disclosure that are present in the rest of our capital markets. So that's another area that is certainly top of mind for me, in addition to cyber that we've talked about earlier. So those are all areas that are top of mind for me.
And I would just note for everyone here too, you kind of slipped in a question in Form PF about the definition of digital assets in the Form PF proposal. So if you're interested in digital assets, but you didn't realize you needed to look at the Form PF proposal, everyone should look at it. There's a question about it there, and we put it in, again, another plug for a longer time to comment on such an important definition.
Yep.
Well, we've run out of time. I have a million questions, but thank you very much. We really appreciate your sharing your perspectives and views with us today.
Sure, I'm happy to. It was a pleasure to be here, and feel free to, again, anyone, I have an open door policy, so I'm happy to do something like this again and answer some more questions, but I also feel free to come in or WebEx, I guess, at this point, maybe open door now. But I do feel free to please come in and meet with me anytime. I look forward to all of your feedback, and it's really instrumental as we continue to go through this fairly heavy rulemaking agenda.
Well, thank you. Please join me in thanking Commissioner Crenshaw.
Thanks, everyone.